Mr. Hammer.
My lords, my lady, because of the constraints of time, I'm not going to take you to the details of the two Strasbourg cases. Can I just simply give you the references and make a couple of points?
Of course.
You have Al-Masri, which is in Volume 1, Tab 2, MS 1509. And you also have Al-Nashiri, which is Volume 10, Tab 80, MS 4706.
Right.
These weren't cases simply concerned with the state's liability within its own territory. For example, in Al-Masri, Macedonia's liability extended to the entire period in which the applicant was detained by the United States forces. Al-Nashiri is particularly striking on the facts because the first applicant in that case appears to have been rendered on the same CIA jet as Mr. Belhaj and Ms. Bouchard, was held in the same black prison in Bangkok, and was subject to many of the same torture techniques as Mr. Belhaj. And the sensitivities in that case, the Al-Nashiri case, vis-à-vis a foreign state, might have thought to be particularly acute because both men are still in United States custody, held on Guantanamo Bay, and Mr. Nashiri, at the time of the judgment and still, is on trial before military commissions.
Is that aspect dealt with anywhere in the judgment of the court?
In Mr. Al-Nashiri, it's stated as a fact. It's not.
No, it's a concern. The point we're dealing with just was ignored.
No. Strasbourg, just get on and deal with it.
Right. No, exactly. That's what I wondered.
Yeah.
So it's a sort of looking for the dog in the night time sort of point.
Well, it's not really. It's just showing the basic principle that when claims are before courts, and they can be as of right, as you can in Strasbourg, as you can, we say, under the common law here, the job of the courts is just to get on with it. And the doctrine that my learned friends contend for has no application. It's that simple.
And the claim succeeded?
And the claim succeeded, yes, on the criminal standard.
Thank you.
The courts carried out a fact-finding exercise
I understand.
On a criminal standard. Now, that is relevant to the point that my learned friends developed on Monday, which is a Carnduff type point.
Yes.
To say, well, you know, this is all very unfair because we can't obtain evidence. And it could be an abusive process. Now, we just need to separate some points here. Insofar as there could be a Carnduff application, that's not the issue before this court. If, in fact, the position is that there is no way that the defendants can fairly advance their case, then they would be entitled to make such an application. Whether or not it's granted will depend, no doubt, on a host of features. What it cannot be is a ground, the mere assertion that that might arise cannot be a ground for founding a doctrine of non-justiciability that disposes of the case at this stage.
I understand.
And what's particularly striking in this context is that that legislation has been brought in on the express basis that it enables fair determination of trials such as these. And that's the Justice and Security Act, the closed material provisions. And that there's a link between the two was made plain by the government in its evidence to the all-party group on human rights. And we have the relevant extract of the government's submission on that. Could I ask you to pick up volume 23, tab 184?
Would the Act apply to this case if there were...
an application could properly be made.
Yeah.
Sorry, could you give me the numbers again?
Of course, my lady. It's volume 23, tab 184, and if we could turn to MS 9392. Now, this was the government's response to the committee's concern that they hadn't been told the exact number of civil damages claims pending before the courts, which was one of the issues relied upon by the government for the passage of the bill. And that answer is given, this is given by the Minister without Portfolio, the Right Honourable Kenneth Clarke. We can pick up the response at the second paragraph of the response. So as of the 31st of October 2012, 20 live civil damages claims in which sensitive national security information was centrally relevant. A number of these cases relate to several individuals. There are also a number of live claims, including some judicial reviews. And then if we could just skip a paragraph. The number of such claims is small, but the issues they raise are very significant. The majority relate to allegations such as false imprisonment, mistreatment, misfeasance in public office, and complicity in rendition. It is vital that the state is not above the law, and it is right that if wrongdoing has occurred, it should be exposed in a court of law.
Do we have the Act?
You don't, my lord, but we can provide copies, that would be
I mean, it
helpful.
may not be relevant, but it would be of some interest.
Of course. Still under this heading, can I turn to the particular point as to whether or not the requirement in these cases for a finding of tortious conduct or a civil wrong by a foreign state amounts to a dividing line between what's justiciable and what's not justiciable. Now, we need to exercise a little caution on this just from the out, because at present the foreign laws have not been pleaded, and thus we cannot know for certainty whether under the Thai Civil Code or the Libyan Civil Code, the liabilities of these defendants requires as a prerequisite a finding that either the US or the Libyans also committed a civil wrong. Different civil codes and different common laws will have different frameworks for establishing liability. But for the purposes of the argument I'm about to make, we can assume that they do. But that's no different to many of the cases that I have already referred to and my learned friend referred to. Take, for example, any case that requires a finding of torture by a foreign state. That is a finding in part of fact, but it is also a finding of law. And in many of those cases, it will be the central issue, or indeed the issue that requires determination. In other cases, and Bennett and Mullen are perhaps the clearest examples, it requires a finding that the foreign country broke its own law, for example, effected an unlawful deportation.
Are those cases based on an unlawful act of a foreign government, or are they squarely based on the involvement of local authorities, the effect of which is to make it improper to try the defendant?
No, the court takes a more global approach as to whether or not there's been an abusive process. And it doesn't say that relates to the proceedings before it. So in Mullen, what was key and what was addressed was the fact that Zimbabwean agents broke Zimbabwean law to effect a deportation with the connivance of the security services.
Precisely.
But it is still central to the determination as to an abuse. Central to that was the breach of Zimbabwean law by the Zimbabwean agents. Now, in this case, my lord, it would be the same type of analysis. What we're talking about is the defendant's liability to these claimants.
Yeah.
So, my lord might be right that you can draw a distinction. Even if the court is drawing that distinction, it's the distinction that can be drawn here.
Yes, I see.
Now, what my learned friend did not do is either identify authority for the proposition that this is a dividing line, nor a principle as to where this should be a dividing line, let alone a dividing line that distinguishes from cases in which there needs to be a finding of torture or of other unlawful conduct. So you're being asked to identify a principle of common law excluding access to a court, the determination of fundamental rights, by reference to a principle unsupported by authority, or reason. Now, yesterday in the course of argument, it was suggested that perhaps the case law of the International Court of Justice could lend some support to that distinction, looking both at monetary gold and East Timor. Well, my Lord's had my learned friend's submissions as to what those relevant passages actually address, and that the submission that it is in respect of the legal effect on a third party. But even if it wasn't, even if that was a rule of international law applied by the International Court of Justice, for the purposes of our own domestic common law, that's irrelevant. Perhaps if it could be said it was a rule of customary international law in relation to how all courts should operate, one could say, applying a Trentex-type analysis, well, it's directly incorporated into the common law. But nobody's suggesting that. So you can't identify the principle of an immunity based upon a distinction between a finding of legality or just being an ancillary finding of no... You can't base that, found that on that ICJ case law, even if it said that which it's contended it says. Could I move on, still under this heading about political and Shergill, and just make one additional emphasis that underscores the importance... I'm so sorry.
Just getting back to your last point, what did Mr. Eadie really pursue that distinction? I thought he said that it's not really so much a distinction between ancillary and direct liability, it's a distinction between cases where the British government is the only party involved, the only state party involved, and cases where, whether it's a co-principal or an ancillary or whatever, another state is involved whose conduct would inevitably have to be scrutinised.
Yes.
I thought that was the slightly different distinction.
Well, I was picking up, perhaps again, showing no subtlety, some comments that we had thought the court was making a potential distinction to be drawn between a case that requires an actual finding of illegality, or in this case, civil wrong, and by a foreign state, and one that does not. But
yeah, well, I think that is the distinction that Mr. Eadie is drawing, but it's not so much an ancillary main protagonist distinction as a distinction between cases where inevitably a foreign state's conduct has to be examined and cases where it doesn't.
Yes, and my Lord, my submissions are meant to address that point.
Yeah.
One should just recall that, of course, in one sense, it requires finding. Let's assume, for the present purposes, that under Thai civil law, in order to find the appellants civilly liable, there needs to be a finding that another party was also civilly liable. So that would, on my learned friend's analysis, give rise to difficulties. He says, present themselves. But that doesn't require, for the reasons that my learned friend gave yesterday, that doesn't require any finding of legal effect as against those other parties. It is merely a construct under foreign civil law that allows you to determine the liability of the appellants. There's no res, there could be no res judicata between the claimants and any other party, any other non-party protagonist. So to say that it's permissible to determine whether country A tortures and has committed an act of torture for the purposes of one set of proceedings, but impermissible to say that for the purposes of establishing liability against the appellants, and Party A acted contrary to the civil code of Thailand, is so artificial as to be meaningless, and certainly not one that warrants the development of an immunity. I was just going to go on, if I may, to deal with even in cases in which courts have discretion and cases without a domestic foothold, our courts have given a stress to the difference that there may be where claims are brought as of right. Can I do this, because this is a case with a domestic foothold, do this with a light touch by references, if I may. Firstly, CND, Volume 6. Oh, can I have it? Sorry. For tab 48, MS 3658. And in particular, the judgment of Lord Justice Simon Brown, paragraphs 36, 37, 38, 40, and 47, Roman numeral 1. And Mr. Justice Richards, 61, Roman numeral 1, and Roman numeral 3. Abbasi, and in answer, I didn't give my Lord an accurate answer this morning. My Lord Lamance asked about what would happen in Guantanamo. Of course, there has been litigation before these courts in which it was said that these defendants had a liability for what went on in Guantanamo. That was, this court, first case Al-Rawi, was a case that stemmed from that litigation. This was an earlier Guantanamo case, Volume 7, tab 50, and the relevant passages are 51 to 57, starting at 3721. And for your note, see the criticisms of the court of the legality of the detention at paragraphs 64 and 66. Finally, Noor Khan. I'm going to give you references, if I may, to Lord Justice Moses in the divisional court, because he draws the distinction most clearly between cases as of right and discretionary relief, and you find that in Volume 30, tab 238, Supplemental MS 112, paragraphs 21 to 25, and conclusion 57. Nothing in my submissions is meant to suggest that Noor Khan at either level was wrongly decided. That was a discretionary case. That was the distinction made by Mr. Justice Leggett below. Can I turn to my fourth of 6 points?
Yes, of course.
Asserted harm to foreign relations not relevant to these claims. Can I just deal with that briefly? It's a claim of executive necessity, long rejected by these courts, not least in Entick and Carrington.
I was going to say, I imagine that's why Entick and Carrington is in the bundle.
That's why Entick and Carrington. But another equally important citation is contained in the judgment of Mr. Justice Leggett, which is, of course, the case of Crown against Wilkes. And you'll find that citation rejecting this plea in his judgment at paragraph 169, MS 1001. And it's the respondent's position that receipt of evidence on this nature, and the court had evidence from Dr. Bristow in both cases, is for a claim as of right, is constitutionally improper and misplaced. If it were to be accepted, and if that evidence were to stand as the evidence upon which this doctrine of immunity exists, it would put the question of justiciability either in the hands of the executive or in the hands of the foreign state to express concern. Would also, no doubt, give rise to a host of unhelpful satellite litigation. Is it permissible for the court to go behind that evidence? If so, what test should apply? Should the claimants be given disclosure so that fairness in order to fairly assess that evidence? Can this only be done in closed hearings? My fifth point turns to comity. And it's our submission that it would be unprincipled to recognise a freestanding rule of non-justiciability of claims as of right based upon notions of comity. This is not only because it's a vague phrase, capable of meaning different things in different contexts, from good manners to respect for territorial sovereignty, but because it can't, as a matter of principle, displace a claim as of right. This was a point made clearly in the case of A against B Bank.
A versus what?
B Bank. A case in the Court of Appeal, which you'll find at Volume 7, tab 55. It was a case concerning infringement of a UK patent concerning the manufacture of security paper for banknotes. It was dismissed by the first instance judge on two grounds. One, justiciability, secondly, comity. It's the comity passages that in particular I wanted to take you to, where the court essentially adopted submissions for counsel for the appellants, and we'll see that if we turn to paragraph 17, MS 3974. And see also in the judgment of Lord Justice Morritt, paragraphs 28 to 29, MS 3978. And this is in a case in which the consequences of comity might have been thought to be particularly sensitive. After a right to defend borders, one key element of the sovereign state is the right to issue currency.
Which,
Can I also, well, we have
which paragraph of Lord Justice Legate's judgment is the one where he accepts Mr. Sumption's submission?
Exactly, 17 to 18.
Can't think why you've drawn our attention to that.
It's not entirely the reason why. But I would also, just before we turn this away, just direct your attention to paragraph 25 in the judgment of Lord Justice Morritt, where the principle of non-justiciability is not to be confused with that of state immunity.
Sorry, that was 25.
Paragraph 25,
Yes.
MS 3977. Important that state immunity, which has been removed by the State Immunity Act, shouldn't be reintroduced under the guise of the principle of non-justiciability. And obviously that's in the context of a commercial exception, but
These are horrible.
it's of some relevance. Now, as I said at the outset, nothing in these submissions should be taken as saying that comity is not a principle that can play any part in judicial decision-making. It can properly do so in a number of ways. I mean, to give you two examples, the firstly is on the question of judicial discretion. And we've seen that in the cases concerning judicial reviews and applications for declarations where there's no domestic foothold. Al-Haq, CND, nor Khan. It can also be relevant in particular types of applications, not least an application to serve a claim form out of the jurisdiction where a forum non-convenience argument arises as to whether or not justice can be done in that foreign country. In Altimo Holdings, just for your note, Volume 4, tab 29, MS 2562, Lord Collins, delivering the judgment of the Privy Council, rejected the proposition that Buttes precluded a consideration as to whether or not a foreign court was corrupt. See for your note, paragraphs 96 to 7, paragraph 101. Finally, under this last heading on our primary case, can I just turn again quite briefly to the comparative jurisprudence? And we see an approach of the court that where claims are brought before it as of right, they cannot be defeated by incantation of a prohibition simply of sitting in judgment of foreign states. I'll start by showing you two Australian decisions, the first of the Australian High Court in a case called Motti, which we'll find in 20, tab 158, MS 8427. This was a case strikingly similar to a Mullen or Bennett type case and concerned whether a prosecution should be stayed for an abusive process where the applicant had been unlawfully rendered from the Solomon Islands to Australia. We can see, if you turn to 8430, the submissions on behalf of the Crown, 5 lines down, that it wasn't appropriate for an Australian court to examine the question of the legality of the actions of the Solomon Islands governments. Courts will not adjudicate upon the validity of acts and transitions of a sovereign state within the sovereign's own territory. This is a well-established principle and is applied in the United Kingdom. The High Court was having none of that, and we can see that if we turn to paragraph 46, MS 8445. And if I could ask you, please, just to read to 45 to the end of 52 on 8447.
He wants to read that now.
Well, I mean, perhaps I can perhaps I can mark it up for reading. The High Court of Australia, it's in emphatic terms, we say, on this point. Can I then, in that case, move straight to the next?
If you're happy with that, yeah.
I'm happy with that, my Lord, safe in the knowledge that, of course, the court will read it.
We will.
With interest, you'll see Underhill, Buttes, they're all considered.
Yeah, I noticed, yep.
And the key point is, there's an issue that the court has to decide. And so when a court has to decide something, it decides it, irrespective of what the implications on in other realms of political life might be. And that is the point that was also made in the judgment of His Honour Judge Peram in the Habib case, another Australian case, this time in the Court of Appeal, which you'll find in volume 21, tab 160, MS 8636. Now, this is a case with strikingly similar facts to those before this court. It was said that Australia was liable in the tort of misfeasance for aiding and abetting torture and mistreatment of the appellant while he was detained in Pakistan, Egypt, Afghanistan, and Guantanamo Bay. All 3 judges held that the Act of State doctrine did not apply. 2 of them, and I'll return a little later to those 2, based their analysis that it couldn't apply in a human rights context. But if I could just show you His Honour's Judge Peram's analysis, which is, we can pick up at paragraph 23. And if you could mark through
60.
I'm so sorry. 23, you will find at 8643. And all the way through to 29. And then 37, 38, 42 to 45.
Didn't he rather put it on the basis of the Australian Constitution? Yes, and does that matter?
No, the Constitution essentially gives the rights, establishes the jurisdiction of the Australian Federal Court to hear the complaint. So we don't need that. We've got the common law. Yes, yeah.
28.
Now,
Yes, well, we're described as turbid waters.
Yes. Yeah. I think if this case has established anything, the review of the authorities. Could I show you a similar approach by the United States Federal Court of Appeal for District of Columbia, holding that this was not a doctrine that had any application in respect of claims against the executive. That's in a, I hope it's a copy that's now been placed before the court. It's the case of Ramirez against Weinberger. No, it's going to be handed up now. It's a case interesting for those with an interest in not only American judiciary, but American politics. It was a court on which Judge Ruth Bader Ginsburg sat with the majority. Justice Scalia was dissenting with Judge Borg and Kenneth Starr. So it's populated with legal personalities.
And moderately expressed views, isn't it?
Well, it's been handed out. Let me just tell you, it's a case that was brought against the United States Secretary of State for Defense and Chief Engineer of the US Army by a United States citizen whose land in Honduras was said to have been taken by the United States to run a military facility where they were training El Salvadorian paramilitaries. The plaintiff sought declaratory and injunctive relief for occupation and destruction of the property. The government's motion to dismiss was rejected on a number of grounds, including the inapplicability of the Act of State doctrine. I'll turn to that in a moment, but could I begin by looking at their consideration of justiciability at page 1512 of the report. And if I could ask you to mark from first column in the area of foreign affairs, 1512, over the page to 1513 to the end of the first substantive paragraph, essential to a resolution of the claims. But the finding here was that, of course, there are some areas of foreign affairs that are out with the competence of the court, but those that are governed by law are paradigmatic issues for resolution by the judiciary. It's an important passage of the judgment that we would ask the court to again consider in full. One other passage before we get to...
Sorry, which paragraph was that?
We're on page 1512, my lord.
Yeah.
In the area of foreign affairs, over the page to resolution of the claims.
I'll ask you to read it in full, please. I'd ask you at 1530 to mark the first paragraph under separation of powers.
1530, right.
Yes, and you'll see the quotation from Chief Justice Taney in Mitchell and Harmony.
Yes.
And then 1542, second column, 42, the passage starting, the Supreme Court has never applied the Act of State doctrine to bar adjudication of constitutional claims by a United States citizen against officials of the United States government.
Yes.
All that passage over the page, the end of that first paragraph.
Up to conclusion.
Yeah.
Okay. Right. We'll read that, yeah.
That was a case relating to a US citizen, but under our English common law, no distinctions can be drawn between a claim brought by a United Kingdom citizen for breaches of fundamental rights by our executive and any other person.
Well, that's quite controversial, isn't it, in the context of Act of State?
In respect of Crown Act of State, it is, my lord, and there's a split view in respect of in the Crown against Nissan.
Yes.
5 of their lordships, 3 reached one view, 2 reached the other. But that's in respect of that particular doctrine, and a rationale is given for that particular doctrine. But as a matter of first principle, there can be no difference, no distinction drawn for redress against the United Kingdom government in its own courts for breach of for torture and false imprisonment, whether or not somebody is a citizen or a non-citizen. I think it's fair to say we established that since Somerset's case. So, my lords, those are the cases, both in the Australian courts and the American courts, that concludes the 6 points. Can I draw together, just by 3 very simple propositions drawing from that, is that firstly, the Act of State, the narrow Act of State doctrine is just an expression of a rule of private international law. Secondly, whether claims are justiciable is to be determined by the clear and cogent framework in Shergill. And thirdly, that applying those principles to these cases, they are justiciable. No rule of international law, no common law principle dictates otherwise. In respect of international law, it was put, we say with respect, eloquently by Mr. Justice Leggett at paragraph 156 of his judgment, MS 997. Having explained that international law didn't require this rule of actor state doctrine, his lordship said, that being so, it's difficult to see why the common law should afford greater respect for the sovereign authority of other states than is required by international law. To recognise an obligation not to adjudicate an act of foreign states when the courts of other states do not acknowledge any similar obligation and none exist in international law is not to treat all states as equal. It's voluntarily to adopt a position of inferiority to other states, which is out of keeping with international norms. My lords, my lady, before I turn to our secondary case, can I just clear up a couple of matters from before? I'd ask you to read quite an extensive passage from Occidental at the Fifth Circuit, but I did miss out a key passage, and I wonder if we could just see that again. It's in Volume 1, Tab 10, and the additional passages you'll find at MS 1808. I think I'd ask you to stop reading after the first paragraph, philosophical limits.
So 110 and where?
I'd ask you, my lord, to read 1808. I'd ask you to read a long passage ending at 1808 at the end of the first paragraph beyond its philosophical limits. Yeah. But I would like you to read, please, the rest of that paragraph of 12, so the next paragraph beginning the international law, because it also develops slightly beyond my Lord Mance's point that this is all about a realm at which international courts can tread but not municipal courts. But it goes a little further than that to make the point that actually there are no laws in this case that would enable, municipal laws that would enable adjudication. And this is the passage in which we find the phrase judicial no man's land that Lord Wilberforce relies on in Butes. Secondly, and some trepidation, Blad, we're going to hand up this evening, not now. It's the description of Blad and Phillips and Eyre in the House of Lords, describing Blad as a case about Danish accents in Danish territory, and describing it as a conflict of laws case in the recognition of foreign laws. Not sure necessarily that it's going to be the deciding point in this appeal, but we thought that the court should have that. And finally, reviewing online the Law Commission report, I was reminded that my Lady Hale was, of course, a member of...
well, why did I ask the question?
that Law Commission. It provides a comprehensive explanation as the rationale for the introduction of the Act. Yeah. But subject to a final review tonight, I'm not sure there's anything in there that particularly pertains to this case.
Right. I didn't think there was, but then my memory is not good enough for me to know every word of every report to which I was party.
Can I turn to our secondary case? And this assumes that the Court of Appeal in Belhaj were right to hold that a doctrine exists that's wider than the Shergill categorisation and that's engaged when a court is asked to reach critical conclusions about the actions of foreign states. It assumes that there exists a category of cases that might be justiciable under a Shergill analysis, but nevertheless should not be determined because of wider prohibition sitting in judgments on foreign sovereigns. Now, if that, contrary to our primary submissions, is correct, then the Court of Appeal were equally correct to conclude that it's of no application to claims concerning acts of foreign officials outside their sovereign territory and of no application to cases concerning fundamental human rights. Now, the appellants accept the existence of both the exceptions, although they're a little circumspect about territorial, they accept that the territorial exception can apply to foreign legislation, but it has no application to other territorial, extraterritorial sovereign acts. In respect of human rights, they say it's an exception, but only one that applies where those human rights breaches have been proven or admitted. I deal with territoriality first. The Court of Appeal dealt with this at paragraph 127, that's MS 387. Neither of these exceptions were relevant to Mr. Justice Legate's analysis because of the approach that he took. It's obviously, if a claim is properly deemed non-justiciable, whether or not there's a territorial exception or human rights exception is irrelevant. It doesn't render that which a court can't deal with manageable. My lords, and lady, underpinning the notions of act of state is the rationale of respect for a sovereignty of a country within its own territory. If you can do the eliding approach of the Court of Appeal and elide some of the state immunity and private international law authorities together to produce that rule, there's no reason why the same principles would not apply. So if we're in this territory, there's a territorial exception. So there thus, therefore, can be no basis. If it's about territorial sovereignty, there can be no basis for recognition of an act of a state outside its borders. Non-recognition of an act of a state outside its borders doesn't undermine any principle of international law or domestic law notions of sovereign power. States cannot expect particular respect when they act outside their sovereign territory. Indeed, in many cases, the opposite may be true. For example, under private international law, a foreign decree purporting to have effect overseas, this court dealt with an Iraqi law that was said to have an extravagant extension, that law wouldn't be applied by our courts. In not recognising that law, it wouldn't be acting in a way that was violent to any notion of sovereignty, because sovereign legislative competence is deemed to end at the border. A helpful analogy is the corresponding principle of private international law, that our courts don't enforce foreign penal laws, revenue laws, or public laws. And an example of that, and some thinking behind it, can be seen in the decision of the Court of Appeal in Masogo and Loco, in which my Lord Clark sat, which you find at Volume 5, Tab 42, MS 124. This is a case about whether or not it was an enforcement of essentially a public, 3124, MS 3124, of a public law. Can I again just give you the references, please? You see the rule in Dicey, which is the rule 3.1, set out at paragraph 28, and consideration of the principles, paragraphs 29 to 30 and 32.
Right.
Now, the territorial limitation is consistent with English authority. Butts is the only example of a case in which it is extended beyond it, but then the reasons were those given by Lord Wilberforce. The very question in that case, it wasn't applying local law. The very question was, where was the territory? Was the state acting in respect of its territory? Was one of the questions before it. But the courts have been quick to make plain that it's territorial. I just give you a couple of examples. Firstly, the Court of Appeal in Playa Larga. MS 4224, Volume 8, Tab 60.
224, it will be more than that.
I'm so sorry. It's 4224. And this is another Cuban sugar case, this time arising out of the military coup in Chile in 1973. No act of state defence was available because the relevant act of the trading company was not an act of state, it was deemed. But the court nevertheless considered the territorial exception, and we see that in the passage that's sidemarked. Sorry, my Lord, 4248.
Thank you.
Beg your pardon.
Yes, 80, thank you.
4248.
4248.
Yes.
Yep, thank you. Yep.
My little friend talked to
This
rely...
is the one that went to the Lords.
Yes, it went in Congresso, but the issue of act of state was not considered by the House of Lords. My learned friend seeks to rely on Blads as an example. I'm not going to go back to that. Brunswick is not a case about the extension beyond the borders for the reasons that I gave, and nor is Q8 Airways in the Court of Appeal, which was the only other authority relied upon by my learned friend. We find that in Volume 6, tab 47A, paragraph 318, MS 3502. I think my learned friend took you to a passage in 319, but we need to start at 318. Could I just ask the court to read 318 and 319? MS 3502 to 3503.
But if the rationale of this alleged principle is sovereign acts, why should there be a distinction in the doctrine between acts which happen to be within the territory
because
and outside?
Because the whole notion of sovereign equality on which my learned friend relies is a notion in international law that relates to the sovereignty of the king is king within his own territory, is where it all stems from. It's the notion of sovereignty within your own land. At the moment you start acting outside of that, the rules about the respect for the rationale for respect for sovereign equality has gone.
I can understand
It's the equality
that
between
suspicion
states.
in the context of legislation, which is, as a matter of international practice, territorial. We don't recognise the extraterritorial legislation of other states. But why should the same principle apply to an executive act, since it's absolutely plain that states, without necessarily breaking international law, do perform sovereign acts, sometimes acts of war, especially in the context of foreign relations outside their own territory. Yeah. And these are an integral part. Their right to do this is an integral part of their sovereignty also.
Well, my lord, we of course, this is my alternative case, not the primary one.
No, I understand.
And but that, I'm not saying that as a forensic point. I'm saying that because one has to understand and try and grapple with what's the rationale for this this alternative case. And if it is one based upon classic notions of sovereign equality, and that's a notion that's always understood as giving expression in the two ways that my learned friend dealt with yesterday: in private international law by respect for the acts within your own territory, and in public international law, we won't adjudicate upon any of your acts within our own courts. Now, it's kind of creating a third category, not known in international law, not without any thinking within international law as to why it might exist, as to this category that will just recognise all acts, non-legislative acts, as sovereign for the purposes of not touching them.
So if British officials were in some way involved let us suppose, in an invasion of a Caribbean island by the United States, there would be actions on the basis of secondary liability for torts consisting of damage to property occurring in the invasion.
Well, under our primary case, not even under our primary case, I mean, an act of war would be, of itself, a declaration of war would itself be non-justiciable. If there,
Crown.
So sorry?
That's obviously right as regards the Crown.
Yes.
But as regards involvement in somebody else's war, on what basis is it said that the act of state doctrine would apply to a warlike act, but not to some other violent act outside one's
Well,
territory?
because that's still properly explainable by principles of non-justiciability. I mean, if the claim against the British defendants rested upon the mere fact that they entered into an agreement to go to engage in military action, that is highly likely to be deemed non-justiciable.
Let's suppose they made a base.
So sorry. I was going to say, if during the course of that, it was shown that the British had deliberately conspired with the warring party to imprison and torture an individual, that would be justiciable. I mean, this is not really an argument that addresses the secondary case as the territorial exception. It really exemplifies the primary case, which of course might be covered by two others. I mean, in terms of warfare, there are two other principles in play which are relevant. I mean, nothing I'm saying requires an extravagant extension of anything, quite the reverse. Crown Act of State can also govern the activities of the United Kingdom overseas. And in respect of warfare, combat immunity is also another limiting factor.
None of the, as regards foreign sovereigns, it's only act of state.
Yes.
Combat immunity is a concept peculiar to the arrangements for the foreign acts of the British Crown.
Yes, I mean properly understood, we would say combat immunity is where we get to saying it's not just and unreasonable to impose a duty of care under a Caparo-Dickman type analysis. I think that's where the majority got to in Smith. But our core proposition is, as the Court of Appeal made plain in A and B Bank, as the Court of Appeal in Belhaj set out, and indeed in UKOS, where in UKOS the court said that Butts is probably the only time a case it could be justified going outside the territory of the sovereign. The territorial exception makes complete sense on the notion of sovereign equality. If that is the basis upon which this alternative doctrine is being based, there's no sense in international law, in an international law sense, let alone a domestic law sense, as to why it should go further.
Is there any possible alternative hook to the limitation? I think Mr. Eady was suggesting that territory was the wrong, or possibly the wrong conception of jurisdiction here, and one should be, or why shouldn't one be looking at a broader conception of jurisdiction in some of the examples Lord Sumption was giving, the sort of conception one has under Article 1 of the ECHR?
Well, that's a conception that gives rise to the legal liabilities of a state outside its territory, the liabilities of the state. The principle on which this doctrine of foreign act of state is sought to be founded on by the appellants is all based upon territory. It's all based upon the actual territory over which a sovereign rules. So it becomes even, I mean, the difficulty with this case, I beg your pardon, the difficulty with this doctrine, the Court of Appeal type doctrine, is that it is throwing in so many different concepts to produce this one rule that it demonstrates its non-existence in our primary submission. But I mean, I suppose it could be potentially arguable with the word, but it makes no sense if your principal doctrine is sovereign equality. Otherwise, through the prism of Article 1 of the Convention, you're changing all notions of sovereign equality as understood in international law. There's a difference between responsibility and sovereignty. Yes, can I just, for your reference, where the Court of Appeal in UKOS referred to Buttes as a unique example of the extension, that's paragraph 68 in the judgment of the Court of Appeal. That's volume 1, tab 3, at MS 1616.
What if the United States government in the present case said that it was engaged in what it did was part of its war on terror, which entitled it to act against anyone who it identified as a terrorist? I mean, that probably won't match the facts of this case, but what if in a case parallel to this it said that, and the British government had given it information which assisted it identify someone, would that be justiciable?
Yes, because the question would be, the framework is, what's the applicable law? Let's look at the tie provisions. Does that amount to could that amount to a defence under tie law? Would there be a defence of necessity or a military requirement under tie law that could negate, could amount to a defence to torture? Now, if there was, you would apply that tie law, or a court may say, we're going to disapply that under Section 14 because we're not going to recognise a foreign law that amounts to a defence to torture.
And insofar as any of the acts took place in what could be regarded as American territory, what would be the position? Would you have to ascertain whether they were really justified on the basis of that there was a war against terror under American law?
You would simply apply the lex delicti, and you would ask, under the lex delicti, does that amount to under that framework, does that amount to a defence? Now, if it does, then you can examine it, but if it doesn't, you don't.
I mean, it's fairly obvious.
It's precisely the type of awkward, potentially embarrassing type of issues to others that courts might have to grapple with in order to determine a right. But that's what courts need to do.
I mean, it's fairly obvious that the American courts would say they wouldn't look at it, isn't it?
They do that for a host of reasons. I mean, not least the political question doctrine that you...
That would mean that we couldn't look at it.
There's state secrets doctrine as well. There's a whole... It's a different framework in terms of cases against the executive in the United States.
So if it was non-justiciable against the Americans, it'd be non-justiciable as against the UK if it had assisted.
Well, not necessarily. I mean, without getting too much into joys, it would a private international law. It would depend to some degree whether that was a rule of procedure or a substance of the foreign law. But I mean, it would be our submission in a case such as that any law that sought to provide a private law that sought to provide a defence to torture would be disapplied under Section 14.
Yep.
It's all resolvable under municipal law.
Okay. Yep.
I deal with the human rights exception. It's applied in Belhaj at paragraph 81 and onwards. You'll find that at MS 368.
Yep.
It was explained in UKOS, on which the Court of Appeal in Belhaj relied. We see that from paragraph 66 onwards, that's volume 1, tab 3. I beg your pardon, 68 onwards, tab 163, page 1616. '69 onwards. 68 is territorial, 69 is human rights, and it's brought together at paragraphs 115. Talking about limitations rather than exceptions to the doctrine. Halfway down in that paragraph, the important thing to recognise that increasingly in the modern world, the doctrine is being defined like a silhouette by its limitations, rather than regarded as occupying the whole ground, save to the extent that the exception can be imposed. That's why we deal with human rights cases. human rights exception is also found in comparative jurisprudence. We can see the approach of the Australian Court of Appeal in Habib. If we turn back to that in volume 21, tab 160, MS 8636, and in particular the judgment of the Chief Justice Black, page 8639. If I could ask you just to read from paragraph 7 to 13.
Paragraph 13 to
Paragraph
6
7 to 13.
7 to 13, right, thank you. Yeah.
Our Honour, Judge Jago, paragraphs 117 to 19, MS 8669. This, like Motti, is an authority that merits reading in full.
Sorry, could I have that number again, please?
8669, my lady.
Thank you.
Paragraphs 117 to 120. There's a more direct approach in the United States. They've developed two strands. Firstly, I've shown you Weinberger.
Just before you leave there, Mr. Hermer, for my note, those two passages that you've just taken us to
Yes. So
confront the question of torture.
Yes.
Is there any wider expression of it in relation to all breaches of fundamental human rights?
Can I check, my lord, and give you the reference
Of course.
to it?
Of course.
There's a more direct approach in the United States. That's shown in two strands. Firstly, the one I've already shown you in Weinberger, that says it's not a doctrine that's applicable to the acts of the United States executive. The second is a rejection that torture and other breaches of fundamental human rights can amount to sovereign acts for the purposes of the doctrine. And that's a consistent...
that sounds rather inconsistent with Jones.
I'm going to come on to that. I'm going to come on to that tension, if I may. It's a consistent theme of United States jurisprudence that acts of state cannot be invoked for breaches of fundamental human rights. As set out in the interveners cases, we see that from the early cases such as Filatiga, and I'm going to show you a much more recent case as well. We also see it reflected in the third reinstatement. Can I just give you the references to that, please, which is volume 25, tab 204, and in particular page 369, which is at MS 10143.
Sorry, what was the...
That's the
10143.
10143.
Which bundle?
That's in bundle 25,
Thank
my
you.
lord, at tab 204.
And this is a restatement, is it?
This is the restatement. It's the third restatement.
Yep.
And it's under the heading Applicability of Act of State to Cases Not Involving Expropriation.
Which page is that?
10143, my
Yep,
lord.
bottom page, yep.
And expropriation, you would accept, would you, as at least as a fallback, is a special case? Is that
Yes. Yes.
based on the fact that the property is there and you have to live with its treatment there?
Yeah, that's, yes. So you'll see there, under the reinstatement, that a claim arising out of an alleged violation of fundamental human rights, for instance, a claim on behalf of a victim of torture or genocide, would, if otherwise sustainable, probably not be defeated by the act of state, since the accepted international law of human rights is well established and contemplates external scrutiny of such acts. The more recent example is a case called Warfor against Ali. This is one of a large number of human rights claims that have been brought under the Alien Tort Statute and under the Torture Victim Protection Act.
Yep.
Can I just ask you to turn to 8325?
Volume?
I'm so sorry. It is
Right,
volume
20.
20,
Thank you.
tab 154, and the relevant passage starts at 8325.
Thank you very much.
And can I just ask you to just mark up the Act of State doctrine section? No need to read it now, but it makes the point that you've seen in the third restatement.
Yep.
Now, it's right, of course, to note
Which bit?
that in some of the...
Which bit of this did you
I'm
want?
so sorry. It's under the heading Act of State Doctrine.
State doctrine.
It's my Lord Habit at 8325.
Thank you.
Over to 8326, yep.
Thank you.
Up to official acts of immunity. Official acts of immunity, yep. Okay. Yep.
Well, that's just code, because are we going to get to all fundamental rights somewhere?
Well, my Lord...
Don't worry,
I think-
if it's not obvious, don't trouble now.
No, but in any event, we'd say the rights that are in these particular respondents' case, the main rights in play are rights that would be recognised in international law as having the status of a prohibition against them has a status in international law of use cogents.
Well, that can't be right with respect to the negligence claim, for example.
No. But in respect of the subject matter of the treatment of the torture,
Yes.
kidnap,
But you've got
and lawful confinement.
Don't we have to look at the... yes, I see. Yes. But that doesn't... I mean, that would mean dropping the Malaysian and Thai claims, because what's alleged against them is not...
There's nothing alleged against Malaysia and Thai. It's all part of what is said to have been a conspiracy to detain for the purposes of rendition to Libya.
But I thought that Malaysia and Thai, it was just said that they weren't part of the conspiracy. They'd just done local wrongs in terms of detaining, I suppose.
The detention is part of the detention for the purposes of effecting the rendition to Libya.
So that's a local wrong on the part of Malaysia.
Well,
And that does amount to say they're part of the conspiracy, doesn't it?
Yes.
if they are asked, to take an example, I mean, obviously, there has yet to be disclosure in this case, but on the basis of the case at the moment, if you can draw a distinction, if the Malaysians are given a request to detain an individual, and that request gives rise to a perfectly proper basis in Malaysian law to detain, it can't be said that the Malaysians have acted in any sense unlawfully. If the person who is asking them to detain is asking them to detain so they can keep them there, so they can prepare the rendition jet to bring them to Libya, then that detention as against the person who asked them to do that would be unlawful. I think that's the distinction that would be drawn. Now, could I turn to address the...
But there was no rendition from Malaysia, was there?
There was no extraordinary rendition in the sense of being put on the CIA jet. No, he's on a plane to Bangkok.
Yes.
I mean, lest there be no doubt, the gravamen of of Mr. Belhaj and Ms. Bouchard's civil claim is what occurred on the black site in Bangkok airport, on the CIA jet, and in the prison in Tripoli.
Well, there is no doubt about that.
Yeah,
but
yeah.
Nevertheless, there are these other bits and pieces.
And I hope I've contextualised how that's put. Can I deal with the instinctive point to this US jurisprudence raised by my Lord Mance, which is, well, that's all very well, but these cases didn't take you very far in the case of Jones. And indeed, it is right, before the House of Lords in Jones, that the House of Lords held them to be of no assistance insofar as they were addressing state immunity under American law. Because in a number of these cases, the American courts held under their own Foreign Sovereign Immunity Act that it did not apply to acts of foreign officials where they committed torture. And that was relied upon by the appellants in Jones. And what the House of Lords said in Jones is that's not particularly helpful because that rule doesn't reflect a rule of customary international law, so it doesn't tell us anything really about how we should interpret immunity in these courts. But there is a vital distinction between consideration of the American cases under foreign sovereign immunity, where they say not official, which we disregard, and consideration by the American courts of a act of state doctrine, which we shouldn't disregard. And the reason for that distinction is this: there is a rationale for sovereign immunity as to why you have to say all acts, including torture, are sovereign, and no corresponding rationale for foreign act of state. The rationale for sovereign immunity is that it doesn't matter what the official is alleged to have done for the purposes of engaging the state's obligations.
Yep.
It will be attributable to the state whether it's torture or speeding. There is no equivalence, there is no symmetry at all in respect to foreign act of state, because there is nothing about the claim that engages that state's obligations. Now, if that is right, the real way to look at this question is what possible justification in common law is there for according the act of torture the status of a sovereign act for saying you will not go behind it. There is a very good rationale for state immunity. It's reflected in international law and customary international law. There is no symmetry, nothing that corresponds on foreign act of state. So you're being asked to look afresh at this from the common law and say, for the purposes of a common law doctrine, shall we say that torture is sovereign so that we won't go behind it? Now, that falls upon the appellants to justify, and they can't do it by reference to Jones.
Understand.
My lords, my lady, can I then just turn to the question of proven breaches and whether or not they need to be proven in order to fall within the human rights exception. As we set out in our printed case, this leads to the very unattractive proposition that justiciability of a claim against the executive before its own courts for complicity in torture can turn upon whether or not the torturer makes an admission.
Yeah.
And here, where a defence of neither confirm nor deny by the executive is served, it would be fatal in every case. And that would be, we respectfully submit, to abdicate the adjudicative function of a court. The plea of Act of State is not said to deprive the court of jurisdiction in the same way as state immunity. It doesn't preclude the court from even considering evidence. If on examination the allegations of torture are not made out, then the claim fails in any event. The court doesn't need to make any critical findings in respect of a foreign state. But if they are found to be proved, then the Act of State fails. And the mere consideration of that evidence cannot itself be a bar. Now, nobody disputes, the appellants don't dispute in this case, that there is any rule of English or international law preventing you from doing two things. Firstly, examination of facts. They accept that domestic courts can examine facts looking at foreign courts. They accept that our domestic courts can identify the appropriate legal standards. What they're saying is you can't marry 1 to 2. But there's no reason at all justifying limiting these cases to proven facts. It's not essential to our case on the existence of a human rights exception, but in the context of torture, it is essentially the finding of facts that are going to be relevant in this case. There is no real issue about determining or not whether they're lawful. The facts itself will demonstrate illegality. Now, to that degree, we are in Time and Sharon territory, which is the case before the Second Circuit, in which the court said it's just obvious that if Mr. Sharon did that which he's alleged to have done, it's going to be unlawful. We're not in Act of State territory. Can I just give you the reference for that? It's volume 22, tab 179, at MS 9019 to 901920, and also again at 9024. Sorry, it's tab. Oh, sorry, it's tab 174. I have the correct MS numbers.
I wondered when you would be coming to Time and Sharon and Kirkpatrick. Are you putting this under the umbrella then of human rights, or are you putting this on the alternative basis, obviously, as a freestanding exception to the alleged doctrine?
It's a freestanding point, Time and Sharon. It's sometimes that it won't actually require looking at making real findings about legality, because the facts itself speak to that and demonstrate that. Should we just, if perhaps useful just to look at it. So we're at MS 9019.
Yep.
And the passages to mark start at 9019, second column. The Act of State doctrine is also inapplicable here. Because even assuming that Sharon's acts or the Commission's findings are Act of State, the issues in this case do not require the jury to pass on the validity of these acts. The prescription of the doctrine is limited to judicial determinations of the validity of acts of foreign sovereigns, the judicial redress of grievances predicated upon a finding of invalidity. And then we see Underhill and Sabatino. In Sabatino, the Supreme Court applied the Act of State doctrine for the limited purpose of avoiding determinations of the validity of official acts of sovereign states and preventing invalidation of these acts. In both cases, the validity of an act or order of expropriation was directly in issue, and a finding for the defendant would have required invalidation of the Mexican or Cuban government's official act. By contrast, the litigation here involves no challenge to the validity of any act of state. With respect to Sharon's alleged acts, no one is suggesting that these acts, by which Time claims Sharon condoned the massacre of unarmed non-combatant civilians, have validity in the sense they cannot be attacked. All agree, Israel, the United States and the world community, that such actions, if they occurred, would be illegal and abhorrent. The issue in this litigation is not whether such acts are valid, but whether they occur. That's the heart of it, and that's the heart of it here. I wasn't intending, unless it would assist...
And why does that matter? I mean, it simply shows that you can have situations where the law is clear, but the facts are what would be required to be investigated. If the Act of State doctrine exists, it presumably covers both, or are you suggesting the contrary?
This is a case in which there can be little doubt that the laws of Thailand, in common with all laws of all civilizations,
I've got that point. I've got that point,
yeah.
But does it matter if the Act of State doctrine exists? I mean, because investigation of the facts is presumably as inimical to the doctrine as investigation of the law, probably more so.
Well, there we scratch our heads. And this is the problem with this vague second notion, because it can't be a doctrine that is engaged by the mere consideration of the facts, because otherwise, how do you explain what courts and tribunals in this country do day in, day out. It cannot be mere investigation of facts. In order to found this doctrine that my learned friend says exists, they have to show something beyond that.
Well, it's investigation of the facts for the purpose of ascertaining their lawfulness.
Yes, and my lord, but if the mere investigation of the facts itself is not precluded by, and there can be, it is impossible to reconcile a doctrine that says you cannot look at the facts with what our courts do.
Well, is it your proposition that the courts of this country always investigate the facts,
Yes.
whether or not they bear on whether a foreign state has done something unlawful? We know that they do in some circumstances, asylum, extradition, whatever, that we've got. But are you going further than that and saying that we always do it, and that the Act of State doctrine simply contains no bar on investigating the facts?
My lord, and I want to be clear and distinguish between the two cases, my primary position and my secondary position.
Well, I appreciate it's your alternative.
But it's an important distinction for answering my lord's question.
Right.
Under our primary case, which is a Shergill-type analysis, there is no difficulty for the court either investigating facts or reaching conclusions, either as to facts or as to law, when it is necessary to do so to determine a claim brought as of right. That is the guiding principle.
Yes.
Now, different considerations might apply if it's a discretionary claim or a claim without a domestic foothold. But that's the principled answer to this. And the difficulties that we are getting into on the secondary case demonstrate that there is a lack of principle behind it. Now, obviously, I want to, if my lords think that there is this freestanding doctrine of non-justiciability, I want to rely upon the exceptions that have been identified to it. But my starting point is it's an unprincipled basis to have this doctrine.
Yeah.
And so the lack of principle is reflected in our inability to grab on to whether they're territorial exceptions and where the human rights exceptions apply. If it's non-justiciable, it doesn't matter what the allegations are. If it's non-justiciable in the Shergill sense, there are no human rights exceptions. The human rights context might help us understand whether it is justiciable or not. But if the only conclusion is it's non-justiciable, it doesn't help me at all what the context is.
Yep.
And, my lord, as I tried to develop before, in the context of fact-finding, let's take a SIAC or a SIAC case, it's not just a question of fact-finding. They're being asked to make determinations of law. Is there a risk of torture, or in the case of exclusion of evidence, was somebody tortured? That's a legal finding. Same with Mullen and Bennett. So I am moving on from the primary case. I'm looking at this secondary, somewhat amorphous concept of freestanding foreign act of state, trying to say, well, if it does exist, the Court of Appeal were right to identify these exceptions. But there is a principled struggle with that because there is no proper conceptual basis for it. That's the doctrine, not the exception. But if there is this kind of common law rule, then as a matter of starting principle, why should it apply? What's the common law justification for applying it to torture? That's the end of the telescope through which this court should be looking at. If you're saying there's a common law rule of non-justiciability, why should the common law justify its application in the context of torture? That's why I started off by saying one needs to look at this through first principles.
Yep.
So, my lord, sorry, this is a very long way to answering my Lord Hughes and Lord Wilson's questions as to why I'm looking and for what purpose at time at Sharon. If we're within this concept of act freestanding, act of state, and if there is a prohibition on making legal findings, Time and Sharon seems to suggest is it's not one that is engaged if, in fact, the facts speak for themselves from a legal perspective. I think that's the highest that can be put. The suggestion...
It was a strikeout application, wasn't it?
Yes.
And didn't go to appeal.
No, that's as far as it went. I think there was a...
Was it quoted with approval by Justice Scalia?
In Kirkpatrick, yes.
This is Kirkpatrick.
I wasn't intending, unless it's going to assist the court, to take the court to Kirkpatrick, because that was a case in which plainly the validity of the act of the foreign official under Nigerian law was not relevant to the determination under the anti-racketeering provisions that the American statutory anti-racketeering provisions that the case was based on. And Justice Scalia expressly narrows the decision, saying that he'd heard lots of argument about exceptions, etc., none of which really applied. And what he did do was refuse to accede to the urgings of the US State Department that notions of comity and executive embarrassment should be a basis for enlarging the doctrine. Having said that, it's the duty of courts to get on and decide cases in front of them. Finally, on the human rights exception, can I take you... can I clarify for your note in UKOS? You'll see it. That's Volume 1, Tab 3, MS 1588. Paragraphs 87 and 90. And can I finally take you on this topic to the rejection of precisely this point by the Australian Court of Appeal in Habib, the point being you've got to have proven allegations. And we can see the rejection of that in the judgment of Her Honour Judge Jago at paragraph 110. So we're in Habib, volume 21, tab 160, MS 8636 at 8667. So paragraph 110, the Commonwealth sought to distinguish the present case from cases such as Oppenheimer and Kuwait, in which the violations of international law were clear, indeed notorious. However, the cases do not support a distinction between known and alleged violations. Moreover, there's no principal basis for such a distinction. As Mr. Habib submitted, there's no requirement apparent in the jurisprudence that the violations of international law and human rights alleged to be established at some indeterminate level of confidence at an interlocutory stage. This must be so. The effect of the Commonwealth's invocation of the Act of State doctrine, if accepted, is to preclude the truth or otherwise of the allegations found in the claim from being tested and determined. The essence of the allegations found in the claim, as ones involving grave breaches of international law and contraventions of Australian law, remain. As in Kuwait Airways, these legal parameters provide the standards necessary for judicial determination and place the present case in a category different from the judicial no man's land apparent in Buttes. It also doesn't explain the distinction. Sorry, I gave you the wrong reference to UKOS a moment ago. It doesn't explain the distinction as to why, in a case touching on forum non-convenience, where there's an allegation that a foreign court will not give justice, the court is able to hear evidence on that and make a factual determination. For the
Well, that's because of the so-called judicial exception.
I'm going to come to that, if I may, my lord. There's no principled explanation, I'm going to contend, that explains why it's permissible for a court to do that, but not permissible for a court to make findings in respect of torture. Now, the justification that is sought to be given for that is that there is a special judicial exception, and that is the passages in UKOS that I mistakenly took you to before. So you'll see that in UKOS at paragraphs 87 to 90. But that, my lords, with respect, does not withstand scrutiny. Because in many cases, considering whether or not justice can be done, the allegation isn't that judges are underfunded or judges don't get the law right. The allegation is the state, or in some cases, the president of the state, fixes court cases. There's telephone justice. Now, that is an allegation that requires the court to make determinations about whether heads of state or senior government officials fix court results. Now, if that is a factual inquiry that is permissible, why, as a matter of first principle, should they not make determinations about whether the same individuals conduct torture or sanction torture? What's the principal distinction? There is none.
Isn't the difference that the illegality of what the foreign state is doing is not itself a critical question that the English court has to answer? As in Kirkpatrick, it is simply the fact. Because all that the English court is doing is applying English law and English standards, usually by virtue of a statutory jurisdiction, to determine whether a power which it unquestionably has, e.g. to grant asylum, to extradite someone, ought to be exercised.
Yes.
And it's completely irrelevant what the legal status of the acts of the foreign government are under its own law or international law.
Well, my lord, there are two things to unpack out of that. The first is the question of the standards that one applies, and then the other is there a distinction between the task that you are conducting? As to standards, there is a stress in the authorities, I think in the passages in UKOS I alluded to, that it's a task that, of course, judges are equipped to, because there are lots of there are obviously we're applying our own standards, and there are lots of judicially manageable standards for assessing it. Well, so here we're applying municipal law. In fact, the law of Thailand and the law of Libya is perfectly capable under the judicial management. And then we return to the question as to whether or not you can identify in common law a distinction because of the purpose for which you are examining the foreign state, that somehow something becomes non-justiciable just because the purpose you are doing it is to give effect to a defendant's rights, as opposed to some ancillary matter, if it could be defined thus, whether or not justice can be done in a third country. Now, that is a distinction in fact. My lords, my lady, it is not a distinction upon which you can found a rule of common law precluding access to the courts. My lords, my lady, that's all I wish to say about the secondary case. Could I simply end by making this final observation? In submissions yesterday, my learned friend, Ms. Kaufman, gave a number of scenarios as the type of cases and the consequences. And they are all powerful ones. But you actually don't need to look further than the facts of this case, and the facts of Belhaj and Butcher, to ask yourself, is the common law in 2015 at a point in which it says, because this requires examination of a foreign state, the claim cannot continue? And I posed a rhetorical question at the beginning, which really summarizes our case, where there is no rule of international law compelling such a result, where there is nothing that can be found in the authorities that compels such a result, when these are claims that are justiciable under the Human Rights Act, as Mr. Rahmatullah's will be by the Queen's Bench Division, why should the common law march the other way? My lords, my lady, unless I can assist the court any further, those are my submissions.
Thank you very much indeed. Thank you. Thank you, Mr. Homer. I think, Ms. Kaufman, you were coming back on something.
Yes, very briefly, I hope. So, my lords, my lady, I was coming back to address Article 14 of CAT, the Convention Against Torture, and also Article 6 of the ECHR. And a lot of what I'm going to do is simply highlight where our case deals with these issues.
That's very helpful. Thank
So far as CAT is concerned, that's contained in volume 18, tab 133, and we will just look at it briefly. Now, these arguments, both that relying upon CAT and that relying upon Article 6 are, as the court will be well aware, they are very much supplementary reasons why we submit, that in addition to our primary reasons, the court should reject the appellant's characterisation of both doctrines, Act of State.
This is a reference. This is a reference to your skeleton or your case, is it?
Our case on CAT
Yeah.
is set out at the appendix to our case, which is in C2, page 256 is where it begins.
Thank you. Yeah.
And we will ask the court in its own time to read that in full, to also read an article by Christopher Keith Hall, which is in volume 24, tab 197, starting at 9902. 197, tab,
Thank you.
page 9902.
Thank you.
And that contains a very close analysis of the history of the drafting of the terms of the Convention Against Torture, its context in respect of other conventions, in support of his case that it has extraterritorial effect. And we would ask, as I say, the court...
Sorry, extraterritorial effect in what sense? Requiring states to exercise extraterritorial jurisdiction over torture?
Requiring states to ensure that it makes provision for reparations in respect of torture committed extraterritorially. So
by its subjects.
Yes, in Jones,
Yes, got it.
in Jones, the House of Lords held that Article 14 of CAT, the requirement to make provision for reparations,
Yeah.
is limited to acts of torture performed within the territory of the state.
Yeah.
We've got
Forum
to be a bit
state.
careful about this article, haven't we?
I'm sorry?
We've got to be a bit careful about this article, even though I may understand what is being said. It says, as explained below, the various justifications given by the House of Lords in Jones, some of which are inconsistent, misapply long-established principles of treaty interpretation and are contrary to the plain meaning of the Convention, its object and purpose, and the travaux préparatoire. So it sounds as if he doesn't agree with the current law.
I cannot shirk from the position that we are taking, which is that he's going to require the court to revisit Jones, and to say that in deciding that the convention is limited to a convention of territorial effect, it was wrongly decided. I can't shirk from that.
Very well.
Is that in your, is that your, I thought you had to give notice that you were going to challenge a decision of the highest court.
Well, we certainly haven't given notice of that, but I
The
think
main
it's
reason for
necessary-
giving notice is so we've got 7 of us sitting, which you've got.
We have the 7 sitting. This is, I would
It would be quite
suggest-
nice for your opponents to know that.
Well, I think it's clear from the terms of our case that
Well, we have-
we have necessarily said it has extraterritorial effects. The necessary implication of that is that it must be taking...
Well, you certainly should have given formal notice. Anyway.
I do apologise for that.
That-
I would
that's
emphasise that this is very much an issue.
No, I appreciate.
And I would also make it clear that the way we are putting this is not the way that the second intervener is putting it. Ours is a more radical position.
Okay.
Really, I would only ask the court to look at it if the court feels it would be of assistance.
That's perfectly fair. Thank you.
But effectively, the basis of our argument is that the requirements of Article 14 are coterminous with the requirements in CAT contained in Article 5 to render acts of torture criminal, and within Article 5, that obligation to make acts of torture criminal has an extraterritorial angle to it, as it were. And our submission is that the two are coterminous. So insofar as one has to criminalise, and that includes criminalising with extraterritorial effect, one also needs to make provision for reparations in respect of such criminal acts to the same extent.
Is it Article 14 in the...
Article 14 is in tab 18. So CAT is in tab 18, and it's one...
Sorry. Yes, it's one... Yes.
Bundle 18.
Yeah, bundle 18.
Tab 133. It's page 7762 is Article 14. Yeah, we got it. Okay. We've got its wording, and then we've got the article you rely on.
Yes, so if one looks first to Article 5, and then what one has to say is read Article 14 as applying to the same jurisdictional parameters as are laid down in Article 5.
Understand.
We also submit, and this is also controversial, we submit that the offences that are required to be created and established under Article 5 are offences that include, as it were, complicity for torture.
Understood.
So that would include the acts of the United Kingdom that are the subject of these claims, and we make that allegation on the basis of the definition of torture as is contained in Article 1 of CAT. So if one looks at Article 1 of CAT, we can see that torture is defined.
It's instigation, consent, acquiescence.
Exactly, and torture cannot be anything other than an official act, and the official act is, in some instances, so for example, where the torture is perpetrated by somebody who isn't an official, it'll only become torture if it was at the instigation of, with the consent of, or the acquiescence. And so anybody who acquiesces, who is a state official, instigates or consents, is committing an offence. And therefore, if our reading of Article 14 is correct, anybody in that position who is a British national must be the subject of a provision for reparation in the civil law of the forum state. Now, we rely upon the Convention, not on the basis it represents customary international law, but on the basis that it is a treaty to which we have ratified, and therefore we should interpret our own laws consistently with those treaty obligations insofar as we are able to do so. Finally, moving on swiftly to Article 6, I would ask the Court also to read Professor Zachary Douglas's article.
Where do we find that?
It's volume 23.
Thank you.
And tab 193.
Thank you.
If I can just give to the Court the parts of
Yes.
the article upon which we rely.
Yes, if you just tell us the
Page
pages.
303.
Could I have the MS, please?
9532.
I'm so sorry.
953.
9533. And he starts on 9533, looking at the Convention on Torture.
304.
And if the Court can read from 303 at the bottom under that heading, all the way through
I think it's 304. Yes, but anyway, it's 9533, yep. All the way through to where?
all the way through to section D, and therefore the end of section D, 9537.
Thank you.
That takes the Court to page 308.
Thank you. Yes, it does.
I see. So again, the effect of this is that Jones is wrong.
That is all about why Jones is wrong.
This is why you call it controversial, yep.
Yeah.
Okay, fair enough.
No, he was junior counsel.
Ah.
He was junior counsel
He was.
Francis.
before
Mann.
the European Court. Yes.
So that's Article 14. Article 6.
Yes.
Now, the starting point here is the Court is either considering or has determined as an initial position that the appellant is correct in its formulation of state immunity, or it is correct in its formulation of the Foreign Act of State doctrine. Can we start with state immunity? And in relation to the clear clash there is between the position of the House of Lords in Holland and Lamp and Wolf and the European Court in Al-Adzani, we do not ask the Court to resolve that debate because in our submission it is irrelevant. Whichever way the debate is resolved, the answer is going to be the same in respect of these proceedings. If the Court concludes that the appellant's characterisation of state immunity represents customary international law, and the Court has our submissions on that, then the Court will necessarily find that there is compliance with Article 6, either because under the Holland and Lamp and Wolf approach, Article 6 isn't even engaged, or under the Al-Adzani approach, because in complying with customary international law and giving effect to the requirements of state immunity under that law, any interference is reasonable and proportionate and pursues a legitimate aim. So the critical question then is whether or not the extension contended for is in accordance with customary international law. And if the court concludes it's not in accordance with customary international law, but nonetheless decides for whatever reason to extend state immunity to encompass a conception of indirect pleading as broad as the appellants have contended for, then our submission would be, at that stage, Article 6 is plainly engaged, because we are no longer dealing with an exclusionary rule, which is to give effect to customary international law.
Well, that goes to justification, doesn't it?
And it would then, one would then go to justification.
But, I mean, the basic problem is surely that if it's a question of jurisdiction and the English court doesn't have jurisdiction because of state immunity, then it's hard to see how it can be depriving anyone of access to a court if it doesn't have any access to give, as Lord Bingham said. But, I mean, it may well be that totally different considerations apply to a common law doctrine such as act of state, which may perhaps better be classified not as a want of jurisdiction, but as a principle of restraint.
Well, certainly, in our submission, when it comes to act of state, that is the correct characterisation. But even when one's looking at state immunity, if one is looking at state immunity, which moves beyond what is provided for in customary international law, then in our submission, the court really is confronting the difficulties of characterisation again. And that is when, in our submission, the observations of Lord Hoffman in Matthews become important, because if the court looks at that extension and considers that there is neither legitimate purpose which is served behind it, or that it's not a proportionate means of achieving that purpose, then to treat that as a matter of substantive law is to undermine the whole object of Article 6. And that in itself would be a reason to say, well, actually, this is a procedural norm so that we are in a position to engage with its legitimacy and its proportionality. It's rather circular, but there is no other way, really, in which sense can be made of Article 6. You have to look at its purpose, and you have to ask at the end of the day, is this effectively an attempt to shut out the courts where they ought properly to tread? And if it is, you then have to ask, is that shutting out a legitimate, for a legitimate reason, and is it a proportionate means of achieving that end? And in our submission, for the reasons we've given about the consequences that would flow from the application of that rule, it simply is not and cannot possibly be conceived as either pursuing a legitimate aim or doing so proportionately. And if I can at this point come back to one of the legitimate aims that it is said to pursue, and that is sovereign equality. And the question that my Lord Chumption raised before, which is whether or not the purpose served behind sovereign equality is exhausted in respect of the actions of a state by a rule of recognition that applies to what it does within its own sovereign territory, or whether or not sovereign equality has a greater purpose to serve in respect of what a sovereign state does beyond its own territory. And I come back to the submission that I made yesterday, which is that that rule of recognition, the conflicts rule, coupled with state immunity on a narrow basis, that is, you do not assert your own sovereign authority over another state, does exhaust the requirements of sovereign equality. So once one moves beyond the territory of a state to its actions on the international plane, it's not right to say that that state is any longer sovereign. That state is, at that point in time, subject to international law. So we're not dealing with the sovereignty of states on the international plane. International law constrains what they do. But we are dealing with the equality between sovereign states on the international plane. That continues. It continues in respect of whatever a sovereign state does within its own territory, but also what it does abroad, in that statesmen remain equal amongst themselves, and what it means is no state can assert itself and its sovereign power over another state. And that is the rule of state immunity. But what it does not mean, and what it cannot mean, is that states are prevented from criticising one another. criticising one another, either in respect of what they do within their own territory or in respect of what they do abroad, and criticising each other to the point of saying, not only you did X, Y, and Z, but what you did was unlawful. It was unlawful, as long as you don't assert your sovereign authority over that statement of illegality by trying to constrain by your own law what it is that that other state can do. So in our submission, sovereign equality gets the appellants nowhere, and what it is left with is the uncertain concept of comity, this nebulous concept, which in our submission cannot begin to justify the extension of the rule of state immunity, or the considerations of practicality, which was something that Mr. Eadie brought up yesterday. But those considerations of practicality, as my learned friend Mr. Hermer has just outlined, cannot possibly be justifiably and proportionately met by a rule which precludes the court from even embarking.
We've been over that.
Yes, the opportunities to look at the circumstances.
We've been over that.
So that is the position in relation to state immunity. So far as foreign act of state is concerned, we do submit that when the court comes to look at foreign act of state as a basis for this extensive rule of preclusion of the court's jurisdiction, it should be looked at purely as a procedural matter. The rule of justiciability based on Shergill, for which we contend, could properly be seen as a substantive rule. The court simply has no competence to make any determination in respect of anybody's rights, and therefore it is a matter purely of the jurisdiction of the court. But when it comes to anything beyond that, then in respect of claims that the court is perfectly competent to determine, the court is being asked to refuse to determine them simply because of the involvement of a third party. Now, that is a procedural bar in our submission. And I need to say nothing so far as whether or not that can be justified, because I simply repeat the submissions that I've made in relation to state immunity for the self-same reasons. It's impossible to justify any such rule. Finally, very much finally, on this question of whether or not there is a viable distinction to be drawn between simply a factual inquiry as to the conduct of a third-party state and a finding of its illegality, the courts do, day in, day out, make findings of illegality. So when they make findings that a third-party state has engaged in torture, that is a legal determination. It's not a factual determination. Torture is a legal concept. It has a legal meaning. It is an uncertain concept, and the court has to engage in an inquiry as to what were the facts, and do those facts meet the definition of torture? Does it cross the threshold from inhuman or degrading treatment into what is torture? And they do that all the time, and therefore the appellant still has to find some kind of principled justification for distinguishing those cases from the cases where it is saying the court should not tread under this doctrine. Unless I can be of any further assistance.
Thank you very much indeed, Ms. Kaufmann. Thank you. Ms.
Oh, one more matter, the
Finally.
examples. We promised to hand up the examples.
Very good of you, thank you.
On a sheet of paper, so if I could do that.
If we get them to the usher, he'll make sure we get them. Thank you very much indeed. That's good of you. Thank you. Mr. Jaffe.
No, thank you, my lord, my lady.
And Mr. Craven. No. Right. So I think we're now on the interveners. Who's going first? Ms. Leven or Mr. Chamberlain? Are you happy talking from there? Or would you rather come forward? Please.
Well, you won't be broadcast if you don't come forward, so you better have. Don't you think?
Good point. Perhaps he doesn't want to. Read how you're dividing up the time between you and Miss Leven.
Yes, my lord, we're dividing it half and half.
Seems
There
equitable.
are two questions which, between us, Miss Leven and I will deal with. The first is is the adjudication of these claims consistent with international law and practice? And I will deal with that, which logically comes first.
Understood.
Second, which Ms. Leven will deal with on behalf of the UN interveners, is the adjudication of these claims required by international law, which obviously encompasses questions under the Convention Against Torture.
Thank you.
I will not deal with those matters, although they're adverted to in our case.
Of course, yeah.
Lords, my lady, there are three principal topics that I would wish to address you on. The first is state immunity, and I propose to deal with two Commonwealth cases that you haven't been taken to yet, some further material on the UN Convention on Jurisdictional Immunities, and an answer to some of the court's questions in relation to the monetary gold principle.
Thank you.
And the attempt by my learned friend to apply that principle to the law governing domestic courts. The second is the interrelation between state immunity and the Act of State doctrine. And the third, some observations on the decision of the Court of Appeal in Noor Khan.
Right.
Can I turn to the first, state immunity? Everyone agrees that state immunity precludes domestic courts from doing things that affect the legal rights or interests, or perhaps, in another formulation, the rights, interests, or activities of a third-party state.
Yep.
The question is whether rights and interests, or rights, interests, and activities goes further than legal rights and interests, or to put it in Lord Sumption's terms, whether the legal interests of a third-party state include its interest in avoiding any adjudication on the validity of its acts.
Yep.
The answer, Lords and Lady, is that the authorities do not include any of them, that's any of the 300 or so authorities that we have, any decision of a domestic court in any jurisdiction applying state immunity in a case where the proceedings would not affect the legal rights or interests of the state concerned, as we would understand that term, legal rights and interests in this jurisdiction.
Right.
The high point of the respondent's case is an analogy drawn, the appellant's case, is an analogy drawn from the monetary gold principle applied by the ICJ. We say the analogy is flawed for reasons I'm going to come on to. But the starting point, we submit, should be how this issue is dealt with by other domestic courts whose position could be said to be equivalent to that of our courts. Now, there are two cases from the Commonwealth in which the principle was clearly stated, and they're both in the same bundle, happily, bundle 20 of the authorities.
Yep.
The first is the decision of the Canadian Federal Court in the case of CADA. Now, it's not the CADA that has previously been referred to. It's a subsequent iteration of that case. It's tab 152.
Thank you.
And the relevant extract is at MS page 8276.
Thank you.
We deal with this in our case at paragraph 16, that's at MS 310.
Thank you.
It was a claim by a former detainee who claimed that Canada had conspired with the US to procure his detention and torture at Guantanamo Bay. The Canadian government argued state immunity on the basis that it would impugn the acts of the US government. And the key section in the reasoning of the judge, Mr. Justice Mosley, is to be found at paragraph 38 to 39. Yes. Just draw attention to a couple of parts of that reasoning. The first is Mr. Justice Mosley saying, starts a judgment by saying, the defendant fails to show how potential judgment of this court holding Canada liable in conspiracy might affect any legal interest of the United States government. No indication that such a judgment might impose any liability on the United States or lead to enforcement against its assets. And then this sentence, the ability of the United States to freely perform its sovereign functions would not be hindered in any way. Now, one of the questions that was asked of my friend Ms. Kaufman by the court was, what exactly is meant by the word activities? We'll come to that in a moment in the UN Convention. Well, here is, in my respectful submission, a very good indication of what's meant by a case which affects the activities of a sovereign state. It's a case where something affects its ability to freely perform its sovereign functions. In other words, it stops it from doing what it would wish to do. And that would be the case, as we'll come on to see, where, for example, a ship that it's using is the subject of proceedings in rem or something of that kind, or something that it is using for its sovereign functions. There are examples given in some of the authorities we're going to come to, are seized in proceedings to which it's not party.
I mean, the first two sentences of paragraph 39 say it all, don't they?
They
From
do.
Point of view.
They do.
Just any circumstances in which the test which you're now proposing would apply to anything other than property cases?
No. And I'm going to come on to show in a moment by reference to the commentary, the ILC's commentary on the UN Convention, that in fact the words that the ILC used were designed to condense into a codified form a series of decisions which represent state practice, all of which are about property.
All about things you might want to do with it.
Exactly. And so that word activities was not put in there. I'll come to show Your Lordship the ILC making exactly this point, but it was not put in there to expand the scope of legal rights and interests. It was put in there simply to ensure that cases where a third-party state's ability to conduct its sovereign affairs was being affected in a physical way, if I can put it like that, by the decision that the court is being asked to take. Can I show Your Lordships and Your Ladyship one further case in the same bundle? Tab 157.
Thank you very much.
And it's the case of Garuda in the Australian High Court. It's at MS, the relevant passage is at MS 8398. The beginning of the case is 8398. The relevant passage is at 8406. It's a construction of Section 9 of the Foreign States Immunity Act 1985, the Australian Act, which is set out at paragraph 9 on 8404. And there the question was whether the defendant company was an emanation of the Indonesian state for the purposes of the law of state immunity. The answer given is that the notion expressed by the term immunity is that the Australian courts are not to impede the foreign state, that's to say, will not by their process make the foreign state against its will a party to a legal proceeding. And that's simply tracking the wording used in the Christina case.
Yes.
You can see footnoted. Thus, the immunity may be understood as a freedom from liability to the imposition of duties by the process of Australian courts.
That's paragraph, sorry.
I'm sorry, paragraph 17.
17, I beg your pardon, thank you.
8407.
I have it now, thank you.
And that we say is a proper encapsulation.
Yes, I see.
Is meant by impleading.
Thank you.
This context.
Yep.
Now, as I mentioned just a moment ago, just asked the court to have a look. I think there's time to look at this before we break today, at the ILC commentary on the UN Convention. That's in bundle 18.
Thank you.
Tab 131, MS 7636. Now, I think it's already been adverted. We've already had mention of the length of the process which led to the drafting of the UN Convention. the ILC produced this commentary to go with the convention to explain what it had intended to achieve. If one looks at the bottom of 7636 under the heading paragraph 2b, which is what we're dealing with here.
Without closing, yep.
Without closing the list of beneficiaries of state immunity, it's necessary to note that acts involving seizure or attachment of public properties or properties belonging to a foreign state or in its possession or control are being considered in the practice of states to be proceedings which in effect implicate the foreign sovereign. If you just read to the bottom of paragraph 13,
Yeah.
and if one looks in particular at the footnotes, one can see from that that every single one of the examples given is a case in which proceedings affect property owned or controlled by a state. None of the examples is a case like the present, where all that the court is being asked to do is impugn the conduct of another state in the course of giving its judgment as between the parties. The second thing that one gets from paragraph 13 is that the difference in wording between the first draft and the second draft of the convention was intended by the ILC to tighten the connection required between the procedure and the consequences to which it gave rise, and not to loosen it.
Yes.
So
where do we see that?
I'm sorry, paragraph 13 on 7637.
It's two sentences.
The words to bear the consequences of a determination by the court which may affect, in the last part of the sentence, was deleted because it appeared to create too loose a relationship between the procedure and the consequences to which it gave rise for the state in question, and could thus result in unduly broad interpretations of the paragraph.
Yeah.
And just to finish off on this point, if your lordships would just turn up again, bundle 23.
Yep. Tab.
Tab 186.
Yep.
MS.
Yes.
9408 to 9.
Right. Yep.
This is part of the commentary of Dr. Grant of the Louterpack Centre at Cambridge from O'Keefe and Tam's work. And if one looks at 9408,
yes.
Second, back midway down the page, one can see, although the verb to affect was introduced in order to narrow the scope of Article 6.2,
yes,
it's not a verb denoting clear limits. Limits are nonetheless necessary. One can then see the recitation below from the US reservation comment that was made on the draft convention, to which reference has already been made.
Yes.
And then over the page, the uncertainty is perhaps addressed by saying that the effect with which Article 6.2b is concerned is a specifically legal effect, such as the imposition of a lien or a declaration of title, as distinguished from a social, economic, or political effect. And an exactly similar proposition can be found in the work to which reference has been made by Fox and Webb. We are not talking here about moral interests or political interests. We're talking about legal interests. My lords, my lady, I see the time. I wonder if that may be an appropriate point at which to break. I've probably got through exactly half of the things I wanted to say. Half can remain for tomorrow morning.
Thank you very much. Very well. We will adjourn now and resume again at 10:15 tomorrow. Thank you very much indeed. Court's now adjourned.